Donald Trump just experienced the most humiliating courtroom confrontation of his entire legal career. A federal judge delivered a public rebuke so severe during yesterday's hearing that Trump's own attorneys visibly recoiled in their seats. We're talking about a 90-minute judicial dressing down that legal observers are calling unprecedented in modern American courtroom history. This isn't just another tense hearing or unfavorable ruling. This is a sitting federal judge systematically dismantling Trump's credibility, his legal arguments, and his courtroom behavior in front of packed galleries, television cameras, and reporters from every major news organization. When a federal judge appointed by a Republican president spends 90 minutes explaining in excruciating detail why everything about your legal defense is frivolous and borderline sanctionable, you know your legal strategy has completely collapsed. Hit that subscribe button right now because you won't want to miss any of the videos I release. So what triggered this extraordinary judicial confrontation that has the legal community stunned? According to multiple reporters who attended yesterday's January 27th hearing in Washington federal court, Trump's legal team filed an emergency motion seeking to dismiss the January 6th indictment based on claims that the prosecution violates the separation of powers doctrine and infringes on Trump's First Amendment rights. Judge Tanya Chutkan, who has presided over the case since August 2023, scheduled oral arguments on the motion and summoned Trump's lead attorney, John Lauro, to defend the filing in open court. What followed was 90 minutes of sustained judicial questioning that legal experts who witnessed it describe as absolutely brutal. Judge Chutkan systematically addressed each argument in Trump's motion, asked pointed questions that exposed logical flaws, and made clear through her tone and language that she viewed the entire filing as a transparent attempt to delay trial rather than a serious legal argument worthy of judicial consideration. And believe me, when a federal judge uses phrases like frivolous and dilatory to describe your emergency motion in open court, your legal credibility with that judge has evaporated completely. Here's the full picture of what's been building toward this courtroom explosion. Trump's legal team has filed 17 separate pretrial motions in the January 6th case over 6 months, each seeking either dismissal of charges or postponement of the trial date. Judge Chutkan has denied every single motion, often in opinions that criticize Trump's arguments as lacking legal merit. The relationship between Trump's attorneys and the judge has grown increasingly strained as the motions continue. Legal observers note that judges typically give defendants wide latitude to raise legitimate legal issues in pretrial proceedings. However, when defendants file motion after motion making arguments that courts have already rejected or that clearly lack supporting precedent, judges begin to question whether the filings serve legitimate legal purposes or simply aim to delay and obstruct proceedings. Trump's emergency motion filed on January 25th appears to have crossed that line in Judge Chutkan's assessment. The motion argued that prosecuting Trump for his actions on January 6th violates separation of powers because the president's conduct in disputing election results falls within executive authority that the judicial branch cannot review. Trump's attorneys also claimed that charging Trump for his public statements about election fraud violates the First Amendment's protection of political speech. Judge Chutkan had already rejected both these arguments in previous written opinions, explaining in detail why they fail under established constitutional law. Trump's decision to raise identical arguments again in a new emergency motion, despite the judge's prior rulings, appears to have exhausted her patience. The January 27th hearing became an opportunity for Judge Chutkan to publicly address what she clearly views as bad faith litigation tactics. Smash that like button if this is making sense so far. Here's where it really gets intense in that courtroom. The hearing began at 10:00 a.m. when Judge Chutkan entered and immediately directed John Lauro to explain why she should not sanction him for filing a motion raising arguments she had explicitly rejected in prior written opinions. Legal observers in the courtroom described the opening as shocking. Federal judges typically maintain polite formality even when disagreeing with attorneys. Judge Chutkan's tone from the outset was one of barely controlled frustration. Lauro attempted to argue that new circumstances justified reconsidering the prior rulings. Judge Chutkan interrupted. She asked Lauro to identify with specificity what new circumstances had emerged since her previous opinions. Lauro referenced the D.C. Circuit's recent opinion on presidential immunity, suggesting it created new legal context. Judge Chutkan's response, according to courtroom observers, was devastating. She noted that the D.C. Circuit opinion actually supported her prior rulings and rejected Trump's immunity claims unanimously. She asked how Lauro could characterize that opinion as creating new circumstances favorable to Trump. Lauro attempted to argue that the D.C. Circuit addressed different issues than the separation of powers argument in Trump's current motion. Judge Chutkan wasn't having it. She stated, and this was captured by reporters in the courtroom, quote, "Counsel, the D.C. Circuit's analysis applies directly to your separation of powers argument. The panel explicitly rejected the notion that presidential actions taken to subvert election results enjoy any constitutional protection. Your motion ignores that holding and instead rehashes arguments this court has already rejected. That is the definition of a frivolous filing." End quote. Legal experts who witnessed the exchange describe it as one of the most direct judicial rebukes they've seen in federal court. And let's be honest for a moment. When a federal judge uses the word frivolous in open court while addressing your filing, you're not just losing the argument, you're being told your legal work is beneath the standards expected in federal practice. Here's what multiple sources familiar with Trump's legal team say happened during and after the hearing. Lauro continued attempting to defend the motion for another hour despite Judge Chutkan's clear signals that she found the arguments unpersuasive. Multiple times during the hearing, Judge Chutkan interrupted Lauro mid-sentence to correct misstatements of law or fact. At one point, she directed Lauro to specific page numbers in prior court opinions that contradicted his arguments. Court observers note that such detailed factual corrections during oral argument are highly unusual and indicate the judge views the attorney as either incompetent or deliberately misleading the court. After 90 minutes, Judge Chutkan stated she had heard enough. She denied Trump's motion from the bench without taking the matter under advisement. She then addressed Lauro directly and stated that if Trump's legal team files any additional motions raising arguments the court has already rejected, she will seriously consider imposing sanctions, including monetary penalties and potential referral to bar disciplinary authorities. That statement sent shockwaves through the courtroom. Federal judges rarely threaten sanctions explicitly and almost never do so in cases involving major political figures where such threats could be characterized as political bias. Drop a comment right now if you saw this coming. I read every single one. Now things get absolutely explosive in terms of what legal experts are saying about this confrontation. Within hours of the hearing's conclusion, legal analysts began appearing on news programs to discuss the extraordinary nature of what had transpired. Andrew Weissman, former federal prosecutor who served as senior attorney on special counsel Mueller's investigation, told MSNBC that in his 30 years of federal litigation experience, he had rarely witnessed a federal judge so openly express frustration with defense counsel's conduct. Weissman emphasized that Judge Chutkan's threat of sanction signals she believes Trump's legal team has crossed from aggressive advocacy into abuse of the judicial process. Weissman explained that federal courts have limited tolerance for repetitive filings that relitigate settled issues, particularly when those filings appear designed primarily to delay proceedings. He noted that Judge Chutkan's public rebuke was clearly intended to send a message not just to Trump's current attorneys, but to any future lawyers who might consider filing similarly meritless motions. Lawrence Tribe, Harvard Law Professor Emeritus and constitutional scholar, provided even more pointed analysis. Tribe told CNN that Judge Chutkan's confrontation with Trump's attorney represents a judicial breaking point where patience with delay tactics has been exhausted. Tribe explained that Trump has employed a litigation strategy across all his criminal cases that involves filing every conceivable motion, regardless of legal merit, in hopes that sheer volume of litigation will force delays. That strategy, Tribe argued, works in some contexts where judges are reluctant to appear biased by denying defense motions too readily. However, when the same arguments get raised repeatedly after courts have definitively rejected them, judges eventually conclude they're dealing with bad faith litigation tactics rather than legitimate legal advocacy. Judge Chutkan's public rebuke in Tribe's assessment serves notice that this particular litigation strategy will no longer work in her courtroom. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. The bombshell assessment came from conservative legal analyst George Conway, who has been a vocal Trump critic despite his Republican credentials and background as a successful appellate attorney. Conway stated in a detailed Twitter thread that Judge Chutkan's confrontation with Trump's attorney may have legal consequences beyond the immediate embarrassment. Conway explained that when federal judges threaten sanctions and warn about potential bar referrals, they create a record that other courts will notice. If Trump's attorneys in other jurisdictions attempt similar delay tactics, prosecutors can cite Judge Chutkan's findings and suggest that Trump's legal team has a documented pattern of bad faith litigation. That could influence how other judges assess Trump's motions in the Georgia case, the Florida classified documents case, and the Manhattan criminal case. Conway also noted that Judge Chutkan's explicit finding that Trump's motion was frivolous creates potential issues for the attorneys themselves. State bar associations take seriously allegations that attorneys file frivolous motions, and while political considerations make bar discipline unlikely in this case, the public judicial rebuke damages the attorneys' professional reputations. Even attorneys who generally defend Trump's legal strategies acknowledged the hearing was a disaster. Jonathan Turley, George Washington University law professor who has argued Trump's prosecutions are politically motivated, told Fox News that Trump's attorneys made a serious tactical error by filing a motion rehashing arguments the judge had already rejected. Turley explained that experienced litigators know when judges have made up their minds on particular legal issues and avoid antagonizing courts by relitigating those settled questions. Trump's legal team either didn't recognize that Judge Chutkan had definitively ruled on these issues, or they calculated that delay was more important than maintaining good relations with the trial judge. Either way, Turley argued, the result was predictable. The hearing damaged Trump's credibility with the judge, who will ultimately preside over his trial and make crucial evidentiary rulings that could determine the case's outcome. Legal experts also analyzed what Judge Chutkan's confrontation means for Trump's trial timeline. Barbara McQuaid, former U.S. attorney and University of Michigan law professor, explained that Trump's delay strategy has been predicated on flooding the court with pretrial motions that require time to brief, argue, and decide. Each motion potentially pushes the trial date further into the future. Judge Chutkan's threat of sanctions if Trump files additional repetitive motions effectively closes off that delay tactic. McQuaid noted that with Trump's primary pretrial arguments now definitively rejected, and with the threat of sanctions hanging over any future filings, Trump's attorneys will be constrained in what they can file without risking professional consequences. That means the trial can proceed on its scheduled March 4th date without further significant delays. Do me a favor and slam that like button because it genuinely helps this video reach more people. This isn't the first time Trump has faced harsh words from judges in his various legal proceedings. Think back to Judge Arthur Engoron's rulings in Trump's New York civil fraud trial, where the judge repeatedly criticized Trump's testimony as lacking credibility and found Trump had committed persistent fraud. Judge Engoron's final ruling included language describing Trump's business practices as unconscionable and his courtroom demeanor as combative and evasive. Then there was Judge Lewis Kaplan in the E. Jean Carroll defamation cases, who issued multiple rulings criticizing Trump's litigation tactics and ultimately found him liable for sexual abuse and defamation. These judges, like Judge Chutkan, reached breaking points where judicial restraint gave way to direct criticism. The pattern across all these cases shows judges increasingly willing to publicly call out what they view as abusive litigation tactics and bad faith arguments. Don't go anywhere. The most explosive part is coming next. So what does this courtroom confrontation mean for Trump's broader legal and political situation? According to legal experts, the implications cascade across multiple dimensions. First, the confrontation signals that Judge Chutkan will likely take a harder line on any future defense motions or trial objections. Judges who conclude that defendants are abusing the legal process tend to scrutinize subsequent filings more skeptically and give less benefit of the doubt on close evidentiary questions. Trump's attorneys must now operate knowing the trial judge views their litigation strategy as problematic. Second, the public nature of the rebuke creates damaging optics. Video of the hearing doesn't exist because federal courts don't allow cameras, but detailed media accounts of Judge Chutkan dressing down Trump's attorney have dominated legal news coverage. The narrative of Trump's lawyer being humiliated in court reinforces broader themes about Trump's legal jeopardy. Third, and perhaps most significantly, the confrontation may influence Trump's other cases. Prosecutors in Georgia, Florida, and New York can point to Judge Chutkan's findings about frivolous filings when Trump's attorneys raise similar arguments in those jurisdictions. If Trump's lawyers attempt to recycle the same rejected legal theories across different cases, prosecutors will argue the arguments have already been definitively rejected by federal courts. That could lead other judges to dismiss Trump's motions more quickly or with prejudice. Political implications also flow from the courtroom confrontation. Trump's campaign has emphasized his legal battles as evidence of political persecution. The narrative requires portraying Trump as a victim of biased prosecution. Judge Chutkan's rebuke complicates that narrative. She didn't rule against Trump based on political views or prosecutorial misconduct. She ruled against him because his legal arguments lacked merit and appeared designed to delay rather than advance legitimate legal claims. That distinction matters to voters who might be sympathetic to Trump, but who also respect judicial authority and legal process. Drop a comment below with your thoughts. I'm genuinely curious to see your perspective. Legal experts also note that the confrontation reveals deeper problems with Trump's legal team. Experienced federal litigators know how to read judicial signals and adjust their strategies accordingly. When a judge issues written opinions thoroughly rejecting certain arguments, competent attorneys understand those arguments are dead and don't resurrect them in subsequent filings. Trump's team either didn't recognize Judge Chutkan's clear signals, or they chose to ignore them because Trump demanded they continue fighting on every front regardless of legal merit. Either explanation suggests dysfunction within Trump's legal operation. Some legal observers speculate that Trump's most experienced attorneys have concluded his cases are unwinnable and have disengaged, leaving less experienced or less capable lawyers to handle day-to-day litigation. If true, that would explain tactical errors like filing motions that predictably anger the trial judge without advancing any legitimate legal objective. This courtroom confrontation also highlights broader questions about Trump's relationship with the legal system and constitutional governance. Throughout his business career and his presidency, Trump treated legal proceedings as public relations battles where winning public opinion mattered more than winning in court. That approach sometimes worked in civil litigation where judges might be reluctant to rule against prominent defendants without overwhelming evidence. Criminal prosecution operates differently. Judges in criminal cases enforce strict procedural rules, punish litigation abuse more readily, and focus on legal merit rather than political considerations. Trump's apparent inability to adjust his litigation strategy to criminal procedure rules explains much of his difficulty. He continues approaching criminal proceedings as though they're civil disputes where delay and public pressure might force favorable settlements. Judge Chutkan's confrontation served notice that such tactics won't work in federal criminal court. Stay with me because what comes next will completely change how you understand Trump's legal crisis. Here's what makes the confrontation even more significant for Trump's immediate future. The March 4th trial date is now just 5 weeks away, with Judge Chutkan having definitively rejected Trump's primary pretrial arguments and threatened sanctions for further repetitive filings. Trump's legal team faces a choice. They can continue fighting every issue and risk professional sanctions, or they can shift to trial preparation and accept that the case will proceed before a jury. Legal experts note that effective trial preparation requires months of work reviewing evidence, preparing witnesses, and developing courtroom strategy. If Trump's team has spent the past 6 months focused on pretrial motions rather than trial preparation, they may be dangerously unprepared for a complex case involving thousands of documents, dozens of witnesses, and intricate legal issues about conspiracy and obstruction. That lack of preparation could prove devastating when prosecutors present their case. The political calendar adds urgency. Super Tuesday primaries occur on March 5th, the day after Trump's trial is scheduled to begin. Trump will be sitting in a Washington courtroom facing criminal charges while Republican voters in 15 states cast primary ballots. His opponents will be campaigning freely while Trump must attend trial proceedings that could last 6 to 8 weeks. The logistics alone create enormous challenges. Trump cannot simultaneously campaign in multiple states and attend mandatory trial proceedings. His attorneys cannot give closing arguments in court while also holding campaign rallies. The courtroom confrontation that has now made headlines reinforces narratives about Trump's legal vulnerabilities during the critical opening weeks of primary voting. If this blows your mind, hit that like button right now. Here's where things stand right now at this pivotal moment. Judge Tanya Chutkan just delivered a public courtroom rebuke to Trump's attorney that legal experts describe as unprecedented in modern federal practice. She explicitly called Trump's emergency motion frivolous and threatened sanctions if his legal team files additional repetitive motions. She denied the motion from the bench without taking time to consider the arguments. Legal experts across the political spectrum agree the confrontation signals judicial patience with delay tactics has been exhausted. Trump's March 4th trial date appears locked in with no remaining viable legal strategies to force postponement. Trump faces the prospect of sitting through weeks of criminal trial proceedings during the opening phase of the presidential primary season. This isn't just another contentious hearing that will be forgotten in the news cycle. This is a defining moment that establishes how Trump's remaining pre-trial proceedings will unfold. Keep a close eye on whether Trump's legal team files any additional motions before trial. Judge Chutkan's threat of sanctions means any future filing will be intensely scrutinized. Watch for whether Trump attempts to replace his lead attorney after this public humiliation or whether Laura remains in place. And pay attention to how Trump characterizes the confrontation publicly. His response will reveal whether he understands the severity of his legal position or whether he continues believing he can win through public pressure on the judicial system. Before we go any further, smash that subscribe button so you never miss content like this. Here's the bottom line. A federal judge just delivered a devastating public rebuke to Trump's attorney in a courtroom confrontation legal experts say is unprecedented. Judge Chutkan explicitly called Trump's legal filing frivolous and threatened sanctions for future repetitive motions. She denied the emergency motion from the bench and made clear she views Trump's litigation tactics as abusive. Legal experts across the political spectrum agree this represents a breaking point where judicial patience has been exhausted. Trump's trial will proceed March 4th without further delay. His legal strategy of flooding courts with motions to postpone proceedings has failed spectacularly. The courtroom confrontation has created damaging narratives about Trump's legal weakness during critical primary campaign weeks. What happens next will determine whether Trump can recover from this legal humiliation or whether the confrontation marks the beginning of his courtroom reckoning. The judicial rebuke has been delivered. The trial date is set. The legal experts have spoken. Now we wait to see whether Trump's legal team adjusts its strategy or continues tactics that judges view as abusive and courts will punish. The stakes have never been higher. The judicial frustration has never been more explicit. The legal crisis has never been more immediate. Pause for a second and hit that like button if you're finding value in this coverage.